Very good evening, my dear friends. This is again the last session on Unit 4, Paper 7, Corporate Laws, Branch 4, PG College of Law, Osmania University, LL.M, 4th semester. Friends, today's the last topic is on the international dimensions of Companies Act. Companies Act, no doubt, is a native legislation, and then whether it has an impact on international arena and what are the international dimensions in this regard. This is what we are going to discuss today. That means in the globalization concept, whether the Companies Act is synchronizing with the global needs of Indian economy, and why other legislations are not taken here. They have no relevance. Companies Act has relevance because it aims at companies. A company incorporated in India, managed in foreign countries, is an Indian company. A company incorporated outside India, managed by Indians, is a foreign company. So you understand the difference. The dimension is that Companies Act provides for foreign management, and then corporates could be incorporated in India. It could be MNCs. In the globalization concept, the multinational companies play a very vital role today. There are umpteen number of companies today with regard to transcription, medical, and then with regard to various other products, IT, where sitting in India, now in home, we will throttle globe. And then the question comes, which law applies with regard to management of companies? And in this international dimension, where there is an admixture of Indians and foreigners, either within India or outside India, and then the companies are incorporated in India, then what would be the international dimension of this subject matter? This is not only relevant to Indian context, it is relevant to foreign countries also. Like you take the Companies Acts enacted in Singapore, UK, US, Canada, Australia. The laws have been amended today. The Companies Act in these countries have been amended. Basically, the corporate principles are one and the same. A corporate entity is an independent personality, different from the members it formulated. This is a global principle. However, there are permutations and combinations with regard to management of affairs of the corporate entity, different from country to country. Now it has to synchronize with international dimensions as to transfer, as with regard to the, the clarity, management, and then transparency, then the logistics, the corporate governance, which I have dealt with last time. So these are all the issues which are synchronized with corporate entity. Competition Act, for example, it has got international dimensions. The laws relating to intellectual property has international dimensions. The law on companies, the company law, has international dimensions. The shares, SEBI sectoral depositories, they have international dimensions. Then the IBC has international dimensions. A company which is subject to IBC in India, the NCLT can go to the extent of going over the properties of that company situated in a foreign country today. That is the international dimension of IPC, read with the Companies Act, and the powers of national company or chapters. That way, we have got a very high configurated network So in this regard, I would like to bring to your notice the provisions which are relevant in this context of the Companies Act with regard to the framework which is based on self-regulation, and then call for enhanced transparency, disclosures and accountability, and a more competent corporate governance in view of the international dimensions. This particular aspect is further going to be made stringent for the reason that the economy has to be put back on its saddle, which has gone back to several years. So here, national and international dimensions will be taken into consideration with regard to the corporate legislations. So friends, the Companies Act, which has got 470 sections, deal with various aspects in this regard, and then it is divided into, as you know, 29 chapters, and then the new chapters with international dimension relate to the registered valuers, chapter 17, government companies, chapter 23, companies to furnish information or statistics, chapter 25, nidhis, chapter 26, National Computer Tribunal and NCLAT, section chapter 27, and the special courts under chapter 28. Some of the students put a WhatsApp note that now library is not available. Don't worry. So far the syllabus of Corporate and Security Laws paper 7 is concerned. Mostly it's based on substantive law from the statutes. And then by this time you must have the statutes in your hand, because our course started somewhere in end of December or beginning of Jan. And then all of you must be having the Barracks. Thoroughly reading certain aspects in Barracks would help you to get excellent marks. Case law is required when there is a conflict. When there is no conflict of law, case law is virtually not required. Even in fact, as a lawyer, I don't argue based on case law where there is no conflict. When there are conflicting issues, opinions, then the clarity has come from Supreme Court over and above the statute. Statute is not clear, confusing, conflicting, then we depend upon the judicial precedents. This is the principle you have to follow, either as a lawyer, as a teacher, or as a student. Take it for granted. Then, most of these particular subjects don't require case law. Because in the existing circumstances, with the existing material limited resources available, we had to cope up with the present situation and then complete the degree. We have been working hard for the last 1.5 years plus. For that reason, I advocate you download from the website Government of India, wherein Indian legislations are concerned. All the legislation which are stated in the syllabus may be downloaded and take prints. Then thoroughly go through with amendments, latest amendments. It contains latest amendments. Does not contain, you call for latest amendments and then click it in Google, you will get it. That runs into several pages, so it is not possible to put all that in WhatsApp. You yourself can do that. You have to do a little hard work from your end also. As now in the present situation, we are struggling to put it on online and then trying to do our best for your welfare. So friends, whether it is regular or private candidates, you can download all the legislations which are meant for the syllabus and then study. In the same way, the Companies Act 2013 also with latest amendments thereon. In the internet, there are a number of articles on the latest amendments, latest dimensions, and all these things can be taken care of. So friends, the Companies Act 2013 has got certain focus on this particular aspect of international dimensions and then brought various definitions, changed definitions, incorporated new provisions, Some of these particular aspects I would like to bring to your notice. It is not exhaustive. You have to study yourself. It is only guidelines. Right. Now, in the Companies Act 2013, new definitions are introduced in the Act, some of which are on accounting standards, auditing standards, associate companies, CEO, CFO, control, deposit, employee, stock option. This is most important. Financial statements, global depository receipt. This is the international dimension. Indian depository receipt, independent director, interested director, key manager personnel, promoter, one-man company, small company, turnover, voting rights. These are all the subjects, in fact, we are supposed to take with regard to the international dimension. Then, the definition of private company has been changed and enlarged to limit on maximum number of members increased from 50 to 200. And then foreign companies definition has been changed, where it could be any company or body corporate incorporated outside India, which has a place of business in India, whether itself or through agent, physically or through electronic mode. See, that is international dimension. And conducts any business activity in India in any other manner. This is the expansive definition. Then KMP, key managerial personnel, in relation to a company has been enlarged and says that the executive officer or the managing director or the manager, the company secretary, the whole-time director, the chief financial officer, and such other officer as may be prescribed. And further, friends, the word officer in default has been enlarged with regard to liability. For example, Section 138 Negotiable Instruments Act. And then the liabilities as attracting to the corporates under various legislations. It could be labor, it could be industrial, it could be economic. So here the officers in default has been enlarged to 1. The whole-time director, key managerial personnel, and then where there is no key managerial personnel, such director or directors as specified by the board. Then any person under the immediate authority of the board or key managerial personnel is charged with the responsibility, including maintenance, filing or distribution of accounts or records, authorizes, actively participates in, knowingly permits or knowingly fails to take steps to prevent any default. Then any person with whose advice or directions the board of directors is accustomed to act, even though he is not named as a director. And then in respect of the issue or transfer of shares of the company, the share transfer agents, registrars and merchant bankers to the issue or transfer. This is the international dimension of the Companies Act. Then friends, I will now take you to the definition of promoter in episode number 2. Thank you.